I'm Steve Donovan, the Director of Alumni Relations at Trinity College. We hope you're well and that your summers are off to a good start, despite the trying times we are living in. Thank you for joining us tonight for another in our series of virtual long walk presentations. We took a little bit of a break over the holiday period and are happy to be back with another star faculty member and a timely topic. We look forward to bringing you additional programming throughout the summer and encourage you to keep sharing your suggestions for additional topics and speakers from the Trinity community. Just email me at steve.donovan@trincol.edu. As many of you know, these presentations are recorded and archived on the Virtual Long Walk website, so you can watch them at your own convenience. And if you prefer to take them with you to the beach or to the pool as you travel, they are also now available as audio files on the college's SoundCloud account. Simply search the web or the Trinity website for Virtual Long Walk and you'll find them all. Now to tonight's program. It's a pleasure to not only present a talented Trinity faculty member, but also to spotlight an impressive current student who works closely with Professor McMahon and has agreed to moderate tonight's session. Maura Thompson is a rising senior from Shelburne, Vermont, and is pursuing her degree in political science and religious studies. Next year, she will be writing her thesis, this is a long one, so hang on the rise of the evangelical religious right within American politics through historical analysis of varying presidential campaigns. Outside of the classroom, if she has any time for that next year, Maura is the president of the Trinitones a cappella group, a tour guide for the admissions office, and a member of her sorority, the Stella Society. She is interning for Practera, an educational technology company, as a research intern this summer. And she's also doing political science research for Professor McMahon. It's now my pleasure to turn the program over to you, Maura. Thank you.
Thank you so much. Thank you, everyone that's here. It's attending alumni, parents, students. We are so happy to have you here. And we are also very excited to give you this talk today. Joining us today is Professor McMahon. He will be giving us a talk about the notable decisions put forth by the Supreme Court during its 2019-2020 term, the varying judicial issues in the upcoming election, and the place of the Supreme Court in our polarized democracy. A little bit about Professor McMahon before we get started. So he earned his PhD from Brandeis University in 1997. He spent time as a graduate student teaching in Russia with the Civic Education Project for 2 years. Most of his research has focused on the presidency and the political origins and consequences of Supreme Court decisions. Professor McMahon has written an award-winning book titled Nixon's Court, His Challenge to Judicial Liberalism and Its Political Consequences. And he's currently in the process of writing another book entitled Uncertain Legitimacy, the Supreme Court in the Age of Trump. Today, he is the John R. Reitemeyer Professor of Political Science and the Director of the Graduate Program in Public Policy at Trinity. Just a little bit about how this talk is going to go. I'm going to give the floor over to Professor McMahon, and then following that, I'm going to moderate a Q&A. We have some pre-submitted questions, and we're also going to open up the floor to anyone who has any questions that may arise during the talk. So feel free to submit any of those down in the chat bar right down below at the bottom of the screen. So feel free to put your questions down. Feel free to put your year, if you're an alumni, or your affiliation with Trinity, just so we can get to know each other. But I have spent a lot of time with Professor McMahon, both in class and doing research with him, and I can't speak highly enough of him. But I know you didn't come to hear me talk, so I'm gonna send the mic over to Professor. So whenever you're ready, go ahead.
Well, thank you. Thanks, Maura, that was great. And for all those out there, Maura's a great student, as you could see. It's a pleasure to have her in class. Thanks to all of you for attending. It's an interesting time for the Supreme Court. You know, June and July is often when we get the most important decisions, and that happened again this year, a little later than normal, but probably because they were off session for a bit because of coronavirus. But we now have them all, and we can talk about some of them. But first, I want to take us back to 2 years ago, and 2 years ago was when Justice Kennedy was retiring from the bench. And as you may recall, this was a momentous event. Justice Kennedy was the so-called swing justice, meaning he sat at the ideological middle of the court, and he had for many years. When there were 5-4 decisions, particularly on the most pressing social issues like abortion and school prayer, he was often the fifth vote and often joining the liberals in those decisions. And once he retired, a number of analysts, sort of predicted what would happen next. I'll focus on Jeffrey Toobin, well known to anyone who watches CNN or who reads The New Yorker. Jeffrey Toobin said that in 18 months, Roe v. Wade would be gone. He said Roe v. Wade was doomed. He predicted that 20 states would make abortion illegal. And he also said things like affirmative action would be gone. The court would be much more protective of things like Second Amendment rights. And obviously it's now 24 months after that event. And my first question, I guess, or what I'm trying to get at least first part of this talk, is why was Toobin wrong? And I guess, how is he wrong? Is he wrong just in the timing, or is he wrong long term, that the court is not going to be as conservative as he was suggesting? Now, to get at this, we need to obviously focus on Chief Justice Roberts. So I'm going to share my screen right now. As you can see, there's Chief Justice Roberts, right? He's been Chief Justice since he was appointed to the court by George W. Bush in 2005, replacing Chief Justice Rehnquist, whom he served as a clerk. And the next slide here is the ideologies of the Supreme Court justices, just to give you a sense of where they sit on the ideological scale. Now, this is from 538. This was just published, I believe, today. But this research is based on two political scientists, Andrew Martin and Kevin Quinn, and they've been doing this for a long time. Now, it is an analysis of the justices as a whole, right? Now, so keep in mind, and some of these are somewhat questionable. Sometimes what's coded as a conservative vote, we might dispute that, but and also for political purposes, certainly some decisions are far more important than others. Some are, most are virtually insignificant for political or electoral purposes. But what you see here is, not surprisingly, for those of you who follow the court at all, Justice Thomas has ever since he joined the court, has been the most conservative member of the court. Justice Alito, the next most conservative. And then you see Justice Gorsuch and Justice Kavanaugh just on the court for 2 terms. And this yellow line, this line that I've highlighted, is the so-called swing vote. And that was held by Kennedy for many years, as you see. And then once, actually at the very end of Kennedy's term, he and Roberts basically overlapped. And since then, Roberts has been the swing justice. The 4 liberals are obviously down here on the bottom. And the way this is set up is the ideological middle is said to be 0. And the farther you get away from that, the more conservative you are in terms of the positive side of this scale, and the negative side, you are more liberal. So as you can see, Justice Roberts, Chief Justice Roberts, is very close to the middle. He's become a little more moderate over his time in the court. At the very beginning, as this writing says, him and Alito were very close to each other. They were appointed at the same time. And what's going on here, right? So how can we sort of understand him and the role that he's playing here? So there's a number of ways to understand. And, you know, social conservatives in particular are particularly often question, you know, why they haven't succeeded in pushing the court in, let's say, overturning Roe, right? Roe was decided in 1973. Republican presidents have appointed 14 of the last 18 justices. They've appointed 10 of those justices since the Roe decision was decided. So, you know, despite all these appointments, all these electoral victories at the presidential level, oftentimes with the Republican Senate, you know, why do they not succeed in doing things like overturning Roe? One way of looking at this is just by focusing on ideology. So individuals in political science like Martin and Quinn are called attitudinalists. And the argument that they make is basically that justices rule based on their ideology, right? And what you see here is that John Roberts is just not as conservative as somebody like Clarence Thomas. He's not that committed to the conservative cause. And there's certainly some evidence about this within the Bush White House when he was chosen. He was not the most conservative finalist on the list of finalists. Bush sort of went back and forth on who to choose. He ultimately had a very good meeting with Roberts, and then he had a conversation with an attorney who was working for him. And based on that conversation, at least the way Bush tells it, he decided that he would choose Roberts. He thought that Roberts would be the best leader of the finalists. By the way, that attorney that he spoke with was Brett Kavanaugh. So things tend to come around, right? Another way of looking at this is the so-called strategic model. If you're a reader of the New York Times, you read articles about the court, you will often see Lee Epstein quoted. She's a political scientist at Washington University. And she is a proponent of the strategic model, certainly informed by the idea that justices decide on ideology, but sometimes it's not purely ideology, right? That sometimes they will make a strategic calculation that delay a decision that would further their own ideological interest for a variety of reasons. Now, the most prominent reason why Justice Roberts has been said to maybe play this role of not being as conservative as some suggest is this institutional idea that he has as Chief Justice, he has a concern about the place, the legitimacy of the court. This is one of the explanations for why he upheld the Obamacare legislation, why he may have decided on, in the Louisiana abortion case from this year, upholding that law as opposed to striking it down. That decision, that law was very similar to a case from 2016 out of Texas. And Roberts didn't want to overturn a decision that was only 4 years old, right? Now, he had dissented in that Texas case. So, you know, we knew where he stood with regard to that type of legislation, but the idea of overturning a Supreme Court decision in such a short period of time on such a divisive issue suggests that the court is very political. And he's somebody who has resisted that idea, really rejected that idea that the court is as political or partisan as many people assert. So that he may be, you know, he may at some point that Tubin might be right. He might deliver this end of Roe, but not now, right? It's the middle of an election. It's a very divisive election. This is a very divisive issue. The court often doesn't reach these very dramatic decisions in the middle of a presidential election year. On top of that, the court has been at the center really of the last two elections. In 2016, you'll recall Justice Scalia had died in February of 2016. President Obama had appointed Merrick Garland. The Republican Senate refused to consider Merrick Garland, so there was an open seat. So the court was at issue there. And then in 2018, right before the midterm elections, the Senate confirmed, again, very close, very controversial vote, confirmed Brett Kavanaugh. So these may be some of the reasons why you might delay. And then, another argument might be that it's the law, right? He's committed to the precedent. He's committed to the notion of stare decisis, let the decision stand, and he's not going to be influenced by the political winds that are underway. Now, some of these, depending on which you find more convincing, would suggest that Tubin is not going to be correct, right? That the court will not overturn Roe versus Wade or push in this very conservative direction. And others suggest that he might, that the court might do that, but the timing just isn't right. I guess the other issue I wanted to highlight before I sum it up is the role of the court in this upcoming election. I mentioned that the court has been an issue, really a central issue in 2016 and 2018. What role will it play this year? And let me just show you, again, I'll share the screen for a second, show you why the court was significant in 2016. So this is an exit poll from the presidential race. People were asked, in your vote, were Supreme Court appointments the most important factor, an important factor, a minor factor, or not a factor at all? And as you see here, 21% of all respondents said that they were the most important factor, and 56% of those voters supported Donald Trump. Only 41% supported Hillary Clinton. And the next one, an important factor, is closer, but that first question is trying to get at enthusiasm on this issue, right? Is a deciding factor. And indeed, when Donald Trump, as president, introduced Neil Gorsuch as his first appointment to the court, he said the Supreme Court issue decided the election in his favor, right? That millions of people went to the polls to support him because of this issue. I don't think the court is going to be that much of an issue this time. There may be some role in the conversation of the campaign as Joe Biden, raises concern about what the court might become, particularly since Ruth Bader Ginsburg is 87 years old and Stephen Breyer is 81 years old. So it will certainly be there, but I don't think it will be as much of a centerpiece as it was, last presidential election. So I'll stop there, and then we can open it up for questions. And so Maura's gonna ask those.
Thank you. That was awesome. That was a great talk. We really appreciate it. I'm going to move forward now with the Q&A. Again, please feel free to submit any questions that you have in the chat bar down below. I'll try to get to as many as possible. I'm going to start with the pre-submitted questions, and then we'll work our way from there. And also a reminder, if you want to submit a question, feel free to put in your year, your affiliation with Trinity, so for fun. All right. So first question is by Aidan Dumas of class of 2020. In this climate, could we expect to see calls for a more democratically appointed Supreme Court, or an increase/decrease in its power given its influence?
Yeah, so there are often calls for the court to be transformed or to have less power, less influence. You know, it's a bit strange that the argument goes that for a nation that is so proud of its democracy, that 9 unelected justices who serve for life have such influence, right? So that's a consistent concern that many have. How it would change, the most popular way to change the court is not necessarily to elect it. Some states elect their judges, and that poses a whole nother set of issues. But really to shorten the terms, right? As opposed to having a life tenure, the most popular one is an 18-year term. That means every justice would serve for quite a long time. 18 years is far longer than obviously presidents and many members of Congress. And it would guarantee that you would have a new justice being appointed every 2 years, right? If you stayed at 9. And this would allow presidents to have an impact, right? That each president in a single term would appoint 2 justices if everything went smoothly. And it would also, the game playing that goes on with sitting justices would be significantly lessened, right? Everyone knows, or I shouldn't say everyone knows, but most people assume that if Hillary Clinton had won the presidency, Ruth Bader Ginsburg would have retired from the court. And that's not just specific to Ginsburg. That's many justices play that role. Justice Scalia said he'd do the same thing. Obviously, he ended up dying before he could retire from the court. So those types of reforms are more prevalent than having something more small d democratic.
Awesome, thank you. Next question is by James Kowalski of class in 1973. Has the court always played into such polarization? How can it be the final arbiter, especially on hot button issues, without dividing us further?
Yeah, I mean, the thing is that this court hasn't been as polarizing as if you compare, let's say, the U.S. Senate or the U.S. House of Representatives, or even the presidency. It hasn't been, this is part of the criticism, right? That it hasn't done things that, for example, that Jeffrey Tubman was saying, that it's been pretty small c conservative in terms of how it's decided on a bunch of issues. It certainly pushed the line. I'm not saying that it hasn't made it more difficult for women to obtain an abortion. It certainly has, but it hasn't gone as far as it could.
Awesome. All right, so I'm seeing a bunch of questions about Merrick Garland, so I'll just ask this question. James Shapiro, class of 81. Do you think Chief Justice Roberts is enough of an institutionalist with regard to the Supreme Court that he's willing to compromise his own personal views on the law to side with the liberals on some very important decisions in order to avoid calls by some Democrats to take back Merrick Garland's seat by packing the court next year with an additional justice or 2 to break a tie?
Yeah, I mentioned a little bit of his role as a protector of the court, the institutionalist idea in the talk. So in terms of Merrick Garland, I mean, the Merrick Garland case is, is very interesting. It's, there are not many times when there's a Supreme Court vacancy during a presidential year. The best comparison is back to 1968 when Chief Justice Earl Warren retired from the bench and Lyndon Johnson sought to replace him with a sitting justice, Abe Fortas, and that was unsuccessful. I think in the end, what happened, one could argue, is that certainly somebody like Mitch McConnell would make this argument that it's not that they stole the seat, but that they paused it, right? And then then Trump won the election and he was able to fill that seat. I don't see the Merrick Garland as problematic as some, because I don't think the Senate, the Republican Senate, was going to confirm him, right? So even if they, invited him to have meetings in their offices, if they held hearings, if they had a debate, if they had a full-on evaluation of him, he was not going to be confirmed by that Senate. And you might, people on the left have criticized President Obama, because he didn't choose somebody who was motivating, right? Who was a symbolic choice, who might have had more electoral power. He chose somebody that was, he thought might be more acceptable to the Republicans. And what ultimately ended up happening is that the Garland issue was not really discussed during the campaign.
Awesome, thank you. All right, so we have a few questions by Robert Rodner, class of '64. What is a reasonable expectation for a Supreme Court justice to be non-ideological in his or her decisions? I feel like we talked a bit about that.
Yeah, I mean, what's really interesting in terms of ideology is the expectation is that they're going to be very ideological, right? That certainly the hope, and you see this a little more on the Republican side, perhaps because they've had so many disappointments in recent years. But the reason why Neil Gorsuch and Brett Kavanaugh were on that list that Donald Trump put out, neither of them was actually on the first list that he put out during the campaign, and then he put out another list, and Gorsuch was on it, and then the list was updated again after he was president, and that's when Kavanaugh's name appeared. But the reason why they're on the list, and the reason why you have people like Jeffrey Toobin making arguments about how they will vote, or predictions about how they will vote, is because they are chosen because they're supposed to be very ideological, at least on they are expected to live. And this is what really bothers somebody like Chief Justice Roberts, that they shouldn't be seen, justices shouldn't be seen as sort of political pawns or, bots programmed to vote in a particular way, that they're there to be not simply a rubber stamp for what, the appointing president wants, but to actually evaluate the case and come to what they think is the right conclusion based on what a specific law says or what the Constitution says. And so that's why I think you do get some surprising cases or surprising results. Particularly, some of the more interesting cases are ones that don't get the headlines. One from the recent term is the one out of Oklahoma, dealing with a Native American treaty, where you had Neil Gorsuch joining the four liberals to decide for the Native American tribe. And that's an example of where he's making a determination based on what he thinks is the right answer, given the history of the case.
All right, so Robert Rodner's second question is very similar to Quanti Davis of class of 93, so I'm just gonna ask them together because they're similar. Is being an originalist mutually exclusive from seeing the Constitution as a living document? That was Robert Rodner's question. And then Quanti Davis is, I'm only a casual observer to the Supreme Court. However, it seems that in nearly every opinion, the majority of dissenter writer often cites the framer's intent. It's impossible to know what the framers truly intended. So doesn't this attribution really suggest that law is interpretive only and not grounded in solid factual discourse? Or is it that the cases that reach the Supreme Court level all tend to be interpretive in nature?
Yeah, so the first part of that, in terms of the originalist and the living constitution, the idea of a living constitution or aspirationalist is the term that we use in constitutional law to describe that idea. Justice Scalia, who is certainly the most, or one of the most important originalists, not only as a justice, but as a law professor before he was selected by Ronald Reagan to be on the court. He always used to like to joke, he wanted a dead constitution, right? He didn't want a living constitution. So to some extent, if you take that, and as somebody who was certainly important to this idea of original intent, that there is a conflict there, that you cannot be an originalist and still have a living constitution. At the same time, originalist, and then another brand of thinking is called textualist. Individuals who read the Constitution, who focus on the language of the Constitution, the actual words or of the statute that they're interpreting. In that sense, you can be a liberal textualist. One of the original justices who began to focus on this idea of textualism, Justice U.S.A. Black, who served from the mid-1930s to the very early 1970s, was a textualist, but for most of his career on the court was quite liberal. So for example, the First Amendment says Congress shall make no law, right? And then it has that string of rights that is focusing on religion, speech, press, assembly. Black wanted to read that literally, that Congress shall make no law, right? So for example, when they were dealing with pornography cases in the 1960s, Black would certainly highlight that. So that's a liberal result in terms of how they viewed the pornography cases, but doing it in a very textualist way, as opposed to somebody who's trying to read words into the Constitution, right? The alternative to that is another case in the 60s, the Griswold versus Connecticut case dealing with contraception. Justice Douglas creates this right to privacy, right? And Black dissents. So these are two great liberals on the court. They're appointed in a very short space of each other, one in 1937, one in 1939. Both are very liberal, but one sees this issue of the right to privacy as, well, you can find a right to privacy within the Constitution, right? This idea of a living Constitution. But Justice Black says, no, you can't, right? And he says, I like my privacy just as much as the next guy, but we just can't create these ideas, right? So even within the left or within the right, you have differing interpretations of the Constitution. Sorry, and then framers' intent, and framers' intent goes to that as well. I mean, for example, in the 1930s with Franklin Roosevelt and his appointments, which included Douglas and Black, they thought that their version of a centralized federal government was consistent with the framers' intent. The difference was that they were dealing with a nationalized economy, and when the framers wrote their words, they were dealing with a much more localized or state level economy. So the conditions had changed sufficiently for a different style of government, but they still felt that they were being true to the framers' intent when they passed laws like New Deal legislation.
Thank you, interesting. So we have a few kind of questions about Ruth Bader Ginsburg, so we'll hit that. Robert Rodner asks, what will likely happen if Ruth Bader Ginsburg becomes incapacitated or, heaven forbid, passes away before the November election with a Republican majority Senate? And someone also asks if Ruth Bader Ginsburg passes away prior to the 2020 election, is it possible for the president to get anyone confirmed prior to the election? So just two clips.
Yeah, I was reading something the other day that said never before in the country have so many atheists and agnostics prayed so hard for a 87-year-old to stay alive, right? So, I think Ruth Bader Ginsburg will be fine, but if she isn't, there will certainly be efforts on the part of the Republican. Certainly Donald Trump, he will appoint somebody and, attempt to use that as sort of a way to attract votes. Because certainly if there's any concern about Chief Justice Roberts and his move to the middle, the fact that another conservative will certainly make it easier for the conservatives already there on the court to advance their agenda. So he would certainly appoint somebody. I'm sure Mitch McConnell would try to get that person confirmed. The problem is that you have, a fairly divided Senate, and you have people like Susan Collins up for re-election in a very tight race. She's actually behind in the polls. So are there enough of those senators who are in close races to vote for another conservative justice, or will they, try to use a vote against the nominee in order to gain votes, when voters go to, not to the polls this year, I think, to their mailboxes, right, to vote on election day.
Okay, interesting. So we have a few questions also. All right, about SCOTUS and the presidency in Trump. So Nancy Wilkes, class of 1974. What do you think the impact slash perception has been regarding Trump's assumption he can control SCOTUS? Obvious, complete disregard for the separation of powers. And then Paul Jones, class of 68. Asks, please comment on the issue of raising the number of SCOTUS justices that has been raised recently.
Yeah, so in terms of the presidency and the court, my work tends to fall within what's called regime politics model of thinking, and the argument there is that that presidents can have an impact. So, for example, my first book is on Franklin Roosevelt, and I argue in that book that ultimately the subtitle of the book is How the Presidency Paved the Road to Brown, as in Brown versus Board of Education. So I do think that presidents can move the court in a particular direction, but it's not as straightforward and direct as, as a president making a promise, a conservative president making a promise to appoint conservative justices who will then, once they get in, do something like overturn Roe versus Wade. That what happens is that the political regimes, when I say that, I'm talking about a president and a Senate in this case, when they get in power, and especially if they're enduring regimes, meaning if you have a dominance of a particular party, over time, given the way that justices leave the court and the frequency in which they leave them, you can certainly move the court in a particular direction. But ultimately, the justices decide, right, and how that happens, and not necessarily what direction they're going to go in, but what that direction looks like, right? So Franklin Roosevelt appoints 9 justices to the Supreme Court. One only serves for a year, so he essentially fills 8 seats. But certainly the issue of race is not a centerpiece of his thinking, but he is interested in appointing liberals, right? Liberal, right-centered individuals. And slowly but surely, they come around to making a conclusion that the Plessy Doctrine should go away, right, in 1954. But it's 1954, it's 9 years after FDR dies, right? So you can have movement, but it's not as rapid as, somebody like Donald Trump has suggested. And the second question, I'm sorry, was court. So the size of the court. The size of the court has changed. Back in the 19th century, it was 10 at one point, 7 at one point, I believe 8 as well. But it's been 9 for a very long time. In the 30s, when again back to Roosevelt, when he was elected. He passed what was known as the first New Deal. The court struck most of it down. He was reelected overwhelmingly and then proposed this court packing plan, which would have expanded the court from 9 justices to 15 justices, basically assuring him, that his new legislation, the so-called Second New Deal, would be declared constitutional. That was rejected. And pretty overwhelmingly rejected, in part because the court changed the terms of its thinking, the so-called switch in time that saved 9, meaning that if not for the switch that occurred, the court would have been expanded. But I do think even though the court is a political institution, and we know that, as I said earlier, that individuals are chosen because of what their perceived ideology is. Ultimately, it's very difficult to sort of play with the nature of the court or the size of the court. That the concern is that if Democrats get in and they expand it to, let's say, 12. Then once Republicans get in, they're going to expand it to 15, right? And that becomes, I think, a great concern. And so why you can come up with arguments that that may be particularly convincing. They stole the Merrick Garland seat, for example. I think ultimately, even people on the Democratic side are somewhat cautious about that.
Great. All right. Next question. Bhumika Chaudhary, sorry if I mispronounced that one. How would you describe the impact of the recent decision on the Electoral College case on November elections?
Yeah, in terms of the ability of, so this case dealt with whether or not electors, so-called faithless electors, right? So electors are committed to voting for, in this case, either Joe Biden or Donald Trump if he wins a state. So if he wins the state of, let's say Joe Biden wins the state of Connecticut, as he's expected to do, one of those electors will say, no, I don't like Joe Biden, I'm going to vote for Bernie Sanders, right? And then this has happened in the past, and most of the time it doesn't make a difference, but you can imagine a situation, certainly how close our elections have been recently, where it would matter. And the court said states could prevent those electors from doing that. you know, these electors are basically unnamed individuals. They're there to sort of play this role that the founders created. The role is sort of very formal. I don't think they should be making independent judgments that the people of Connecticut were wrong, and that they prefer somebody else. I think, you know, I think that's the right decision.
Don Gillette asks, with the 18-year term reform idea, could justices be reelected?
You know, so it's a good question. I think the thinking is that they wouldn't be elected, but they would be selected. Could they be selected again? I've seen both. I think the notion is that you would get your chance. I mean, 18 years is a pretty long time, and then you would be you'd be done. But certainly, you know, there's ways of playing with that and to coming up with the best system. If you have, you know, a superstar who's become a legend on the court, why would you not want to give that person another chance? Yeah, I mean, maybe there shouldn't be a term limit. But I think most of the time, the idea that I've read, at least, the way it's been proposed is that, you know, you do your time and then you move on. Because the reason for that is there's always a concern with any type of term on a court. In this regard, I'm looking to states who some states have terms in which you can be renominated for. Does that justice sort of play to make decisions that will make it more likely that he or she is reappointed, right? As opposed to making a decision, you know, more straight line down the line decision that if you don't have the opportunity to be reappointed, that sort of strategy has taken away from you.
Great. All right. Antonio Gurola of class of 22 asks, to what extent do you think the modern politicization, excuse me, of the confirmation process, yeah, it is a hard word, of the confirmation process compels presidents to choose more partisan ideologue justices?
Yeah, I mean, that's certainly Republican. You know, Republicans have been very concerned with what used to be called, and people who read the New York Times will be familiar with the greenhouse effect. So the argument was that what happens, you know, I mentioned 14 of the last 18 justices were appointed by Republicans. Many of those, or I shouldn't say many, but several of them were expected to be conservative. Everyone really of those 14 were expected to be conservative, and some became quite liberal. You know, the most well-known individuals were Harry Blackmun, who was the author of the Roe decision, and David Souter, who was appointed by George H.W. Bush, that they became more liberal. And it was called the greenhouse effect because the argument was that these were individuals who wanted to appeal to Linda Greenhouse, who was the longtime Supreme Court reporter for the New York Times, now still writes for the New York Times on occasion. And so what conservative presidents have done is they've really tried to work very hard at choosing the right individuals. And what you have now is a very select group of people who are even possible to be considered for the court, right? You certainly, if you're talking about conservatives, you have to be a member of the Federalist Society. If you're a key participant in the Federalist Society, that's important. We all know you can go to any law school you want as long as it's Harvard or Yale, right? Everyone on the court has gone to either Harvard or Yale. You have every conservative justice. There's a little hiccup in this. Is a Catholic. Chief Justice Gorsuch is a Episcopalian, but was raised Catholic, right? So there's a sameness, right? It's almost like a cookie cutter court that you're choosing. You're just trying to find the right person. Why? Because you're concerned that if you don't find that right person, the next Scalia, he's always the model that's used. You find the next Scalia. If you don't find the next Scalia, you're going to end up not delivering on the promises that you made to your voters.
Interesting. All right. All right, I'm going to try to keep answering as much as we can. I'm going to try to get to everyone's. Mary Ambrose asks, assuming Joe Biden is elected, even if Ruth Bader Ginsburg were to leave the court, unless Mitch McConnell is not reelected, the court might have to operate with 8 justices for an extended period of time. What is the maximum time the court could run with 8 justices?
I mean, conceivably it could run for a very long time. You know, there was some, I think Ted Cruz said that if Hillary were elected, they would keep the Scalia seat, you know, the Merrick Garland Scalia seat open until the next presidential election. That's never happened before. And I think there would be great pressure on the Senate, particularly, you know, senators from bluer states, to bring forth a vote, you know, that they would align. I really think when you get into this sort of playing with Supreme Court seats, whether it's court packing or leaving a seat open for a very long time, there's only so long you can do that, right? So McConnell was able to do that, but he was able to do that because there was a presidential election. So he could say, and there was some support for that, again, with 1968 and Abe Fortas, that he could say, well, let the people decide, right? That they know there's a seat on the court. The people can go and vote for either Donald Trump or Hillary Clinton and make a determination. And that seat was profoundly important, right? Because if you think about that chart that I showed you, the court, the swing justice has been on the conservative side of that chart. So Martin and Quinn identified the ideology of justice as going back all the way to 1937. I just showed you, you know, a shorter version of that. And since 1970, for pretty much every year, the swing justice has been on the conservative side of that ideological line. If Hillary Clinton were elected and she was able to replace Justice Scalia with, you know, somebody like even Elena Kagan, who's, you know, or Stephen Breyer, the more conservative of the liberals, it would have been a much more liberal court. It would have moved the court significantly to the left, if you, again, looking at that chart. So this was a very important issue. Hillary Clinton really didn't highlight it to the extent that she might have. And again, as I said earlier, some people criticize President Obama. Some people on the left criticize President Obama because he didn't choose, you know, more strident liberal for that seat as opposed to choosing Merrick Garland.
Okay. All right. Gail Martin, 75, class of 75. What effect do you think public opinion has on Supreme Court decisions, i.e. legalizing gay marriage? By the time it happened, the public's opinion had really changed over the previous 10 years.
Yeah, it's an excellent question. I mean, you know, obviously courts like to think that they're not, you know, they're not affected by public opinion, you know, that they just read the law and they interpret the Constitution. But you know, as Chief Justice Rehnquist once said, the justices read newspapers too. And it is, you know, the same-sex marriage issue or gay rights issue is really tremendously impressive in terms of how much change has occurred in a relatively short period of time, you know, at least by court standards. In 1986, the court decides in favor of Georgia against the expansion of the gay rights in the Bowers versus Hardwick case, in a decision that is, you know, widely criticized by activists for gay rights. And in the space of, we have Lawrence in 2003, and then we have the gay rights decision, about 10 years later. And then the decision from this year dealing with the 1964 Civil Rights Act. Now, there may be some decisions to come dealing with, religious exceptions that might not be as favorable to gay rights activists, but I think that's one of the areas where public opinion has certainly mattered. That this is an issue in which the American public has altered its views quite dramatically, according to the polls, and there's really, I think, it's understandable to think that particularly some of the younger justices would be influenced by that. In the Bowers case, for example, Justice Powell, who joined the majority, he was the swing justice at the time, said he had never known a gay person. Right? It turned out that his clerk was gay. He just wasn't aware of that. But I'm sure most of these justices have lived their entire lives in places like New York and Washington or Cambridge, Massachusetts, or Chicago, or significant chunks of their lives in those places. So I think not only the public opinion, but as one recent book on the Supreme Court has said, the company they keep, right? That the justices are influenced by the company they keep. So who they interact with becomes important as well.
Awesome. I think we have time for one more question. I'm sorry I couldn't get to everyone's. They're all great questions. I wish I could get them all. How do you think the COVID pandemic may affect the court's view of limits on government power or government healthcare legislation? Question was by Ward Kelsley, class of 65.
Yeah, that's another great question. I mean, as I'm, thinking about my syllabi for next fall, and well, I guess in the January term, I'm thinking about how, these issues that are raised with the coronavirus, the wearing of a mask. Do you have a freedom not to wear a mask? How stringent can governments be? It really raises a whole set of issues that the court may have to deal with, depending on how long this goes on. There was one case out of California dealing with churches. You get into questions about not only free speech, or is not wearing a mask freedom of expression? Can churches stay open because they are religious institutions protected by the First Amendment? So it will certainly require the updating of syllabi across the country.
Great. Well, I think that's all the time we have. Perfect timing. Thank you so much, Professor McMahon. It was really interesting and really great. We really, really appreciate it. And also thank to everyone who helped put the talk together, and also all the alums, students, and families, parents, friends, all that who joined. We really appreciate it. It was so great to see you all. And I wish you all the best. Stay safe and enjoy summer. So thank you, everyone.
Thank you.